Hello, my name is Jason Lazarus, CEO of Synergy. With me is Evelyn Pacino, one of Synergy's MSP expert compliance attorneys. Evelyn has deep experience in MSP compliance-related issues and public benefits. Like me, she is a Medicare secondary set-aside consultant certified and also a certified Medicare secondary payer professional. Evelyn, when it comes to set-asides, it can get very complex very quickly. Can you give personal injury lawyers some brief insights into set-asides and their regulations?
Yeah, so there is a lot of confusion in this area, particularly because there is no law or regulation that actually requires setting up a Medicare set-aside. But considering the risk that a client could have trouble getting their claims paid for post-settlement, I want to underscore just how important it is to pay attention to this issue and not to ignore it just because MSAs aren't mandated. So what the Medicare Secondary Payer Act requires is that Medicare's interests be protected post-settlement. And so the idea is that after the case ends, that any injury-related care should be paid from the recovery if that settlement funded future medicals. And so that's where CMS is getting their authority to deny claims post-settlement. Now, how they enforce it is through a different law, and it's through Section 111 of the Medicare, Medicaid, and SHIP Extension Act of 2007. And what that law does is it requires defense to report to CMS when a case ends, what the injury codes were, how much the settlement was. And so that's how CMS finds out about what was included and how they can flag claims going forward so that they might deny them post-settlement. And so that's really their main enforcement mechanism around whether you should do an MSA or not. And if a client does set up an MSA, CMS can monitor it by requesting an accounting. And so in work comp cases, they require that annually. In liability cases, there is no required reporting at this point. But if a person does spend their MSA down to zero, then CMS might require those records to make sure that the MSA was spent properly. And they might require that before they start paying for injury-related care again. So for that reason, it's really important that if a person does set up an MSA, that they follow those administration rules. So even though an MSA isn't required by law, there may still be consequences for not setting one up or for misusing it. And keep in mind, there's no one-size-fits-all answer here. Every case is different, and ultimately it's going to be a risk assessment type of issue for the client for them to decide whether or not this makes sense for them. So that's why it's critical to analyze the case with an expert who can make recommendations specific to their unique situation.
Yeah, great point. The idea is educate the client, let them understand what the consequences are related to the Medicare Secondary Payer Act, and then make the right decisions for them. So that's where partnering with Synergy for MSP compliance related services like a Medicare expert case evaluation for a client becomes the gold standard in making sure that you protect your client and the practice as well.
Completely agree.